So, okay, my name is Ben Mirza, and I think some of you guys have heard us before, been on our seminars. Like Charles said, we're doing 2 seminars every month, and they're all intended to be really pointed, very like niche driven into the hospital industry, as well as all of the practice groups that practice with the hospital industry. And so what that means is that what we've done is we've really brought some really substantive value into these seminars. So we're, again, healthcare law partners. And Komal, if I can actually have the next slide. This is a seminar. For those of you that just recently joined us, this is a seminar that's being recorded. And as it's being recorded, just know that this is not intended to be legal advice. This is only an informational / educational session. Should you have a specific question that's very narrow and unique, you may want to us offline and discuss it offline. Otherwise, please do ask your general questions here. I think it's the actual right platform for it. So, with that said, a little bit about myself. I have been an attorney for about 20 years. I've worked inside large and small hospital systems. I've worked with physicians, physician practice groups, and a whole bunch of different types of healthcare companies. I am licensed with the Florida Bar and the Washington, D.C. Bar, and I'm admitted to a whole bunch of other certificates and things, and I won't bore you with all that, but we'll get, Komal, why don't you introduce yourself?
Sure. Thank you for the introduction, Ben. I am Komal Mirza. I'm actually Ben's niece. I've known him for quite a while, actually since birth. Unlike him, I don't necessarily collect degrees, but I do have a few. I received my Juris Doctor from Nova Southeastern University, and I have a bachelor's degree in biological sciences and pre-medicine from Florida Atlantic University. Prior to joining Healthcare Law Partners, I was an attorney with the Legal Aid Service of Broward County, where I represented foster care children in state court and advocated for their medical needs. And in my free time, I like to participate in a lot of different bar associations, both professionally and socially. And with that being said, I'd like to turn it back over to Ben.
So before we begin this session, I want to talk about some of the market forces that are in place. So why are we tuning into this seminar, and why is it important to be in tune with this, with the knowledge base that travels under this? So a part of it is driven by the negligent credentialing liability lawsuits that are in the industry. They're rising. The hospital systems that get a CON issued to them, they have a community participation requirement. With COVID-19 on the horizon, there's actually emergency credentialing that's also in play here, and then there's also like a shift in payment structures. So with all that said, there's physicians that are looking to get inside hospital systems, and the hospital administrators need to manage the medical staff better. Now in between all of this, you also have physicians that are dealing with this ever continuous changing environment with a high degree of administrative burden and a lower morale. So all of that sort of stuff drives your medical staff issues inside hospitals. And so today, what we're going to be discussing is, this is our roadmap. First, we're going to talk about the medical staff bylaws and how medical bylaws come about. Then we're going to talk about credentialing and privileging, and we're going to talk about peer review and how that takes place. And then we're going to talk about disciplinary actions. So, yeah. So anyway, so that's our roadmap. But that's and this is going to be about a 50-minute presentation. Komal, you're up next.
Thank you, Ben. So to start off with, medical staff bylaws are legally important for all hospitals to have because they do govern and organize the medical practitioners in the facility. And they really maintain the standard of patient care and quality care. They are required by CMS and other state laws and administrative codes They particularly and specifically only apply to the medical staff members and the allied health professionals. It is important to note that medical staff bylaws are different from or distinguished from the rules and regulations of which apply to medical staff, and the hospital bylaws and policies and procedures of a hospital, which govern the medical and non-medical staff of a hospital. Medical staff bylaws are particularly required to be the result of a collaborative effort between both the medical staff and the board of directors for the hospital. The same applies to the rules and regulations which govern the medical staff as well. The Medicare and CMS specifically lay out the minimum requirements for medical staff bylaws in their Medicare conditions of participation. Specifically, the Code of Federal Regulations, 42 CFR section 482.12, which relates to governing bodies, and 42 CFR section 482.22, which relates to medical staff, are the basic minimum terms that are required to be in those bylaws. And it is important for the medical staff and the board to reference those when drafting your bylaws. This CMS has actually commissioned several different accreditation bodies to help authorize and evaluate whether a hospital is fit to participate in CMS and other federal healthcare programs. The biggest one being the Joint Commission, which is a private accreditation body, and they specifically reference and cross-reference the comprehensive accreditation manual for hospitals. And specifically, the drafters of the bylaws do want to pay attention to the elements of performance in that manual. Other laws that govern the medical staff bylaws include the Healthcare Quality Improvement Act, which provides immunities to provide specific immunity to participants in the peer review process. And that came about as a result of the United States Supreme Court ruling in the Patrick v. Burgett case, which at the time did hold participants in the peer review process liable in claims. As a result of this act, there is also now the National Practitioner Data Bank, which requires self-reporting of any malpractice verdicts and settlements by healthcare practitioners. And that's important for credentialing and privileging purposes as we move forward in this seminar. Specifically, it is important to note that Florida law, along with many other states, have also addressed medical staff bylaws and their minimal requirements. Like all other states and CMS requirements, the medical staff bylaws are considered a contractual agreement, which means that there has to be collaborative effort and an agreement between the medical staff and the board of the hospital. Neither party can make a unilateral decision when drafting the bylaws or making amendments. The reason for this, like I said earlier, the reason for the medical staff bylaws is entirely to ensure the quality of care that's provided in a facility. And it is important for the bylaws to note and provide the due process rights available to medical staff in the event that there are questions or issues that arise with credentialing and privileging. It is important for the bylaws to include a breakdown of the different categories of medical staff membership available to the staff. There are about 4 or 5 different categories typically that hospitals have. The first being active staff, which is staff members which includes staff members that have the right to vote, serve on staff committees, and attend meetings. Provisional staff is the second one, which differs from active staff in the sense that it primarily includes new staff members, and they don't have the right to vote, but they do have the ability to serve on staff committees and attend staff meetings. The consulting staff category is a category for practitioners that are staffed with the hospital under a consultative role only. They don't participate in staff governance, cannot vote, and they are required to attend department meetings. They also do not have practicing privileges at the hospital. And then finally, there's the honorary staff. Honorary staff historically consists of retired professionals who no longer have clinical or voting privileges, but they do stay involved with the hospital in a professional capacity. And finally, there are staff members that may have disaster privileges. And those are staff members that are appointed by a person identified by the bylaws to be able, with responsibility of granting disaster privileges in the event of something like COVID or hurricanes occurring. Medical staff committees and officers are also provided for or enumerated in the bylaws. The most important committee being the Medical Executive Committee, which is the Medical Staff Governing Committee, and to which all subordinate committees like the Qualifications Committee or the Peer Review Committee reports to. The MEC then turns around and provides recommendations to the hospital's governing body, aka the board or board of governors. And essentially, the Medical Executive Committee acts as the communication conduit for both the medical staff as an organization and the board of the hospital. Credentialing and privileging. Like I mentioned, the many things do go into the credentialing and privileging process, and one of the key important parts was the NPDB. Now, it's important to note that the CMS does require all healthcare providers within a facility to be credentialed and privileged. Credentialing is the process of gathering, verifying, and assessing the qualifications of a physician or prospective physician or professional practitioner in the hospital. Privileging is the identification of the services and treatments that a practitioner may administer or provide to patients within a hospital. And it's based on the practitioner's credentials and the category in which the staff member falls into. Now, the credentialing and privileging process is a complex one. It starts out with a credentialing application, which is a series of forms and release, both authorization forms and release forms. That file then goes to the primary source verification step, which is completed by the medical staff personnel. This is where the personnel essentially confirm the qualifications, the training, the education, and the recommendations of the applicant. If the applicant then passes the verification of all of their sources of education and the like, it then goes to the department chair, for which the applicant is applying, to the department chair of the department to which the applicant is applying. Once the department chair qualifies the applicant for a position in that department, the application then goes to the medical staff committee review. This could be a specific committee or subcommittee within the medical staff structure, which reviews the application, or it could be the medical executive committee itself. If the committee finds that the applicant is fit for employment with the hospital, they will then provide a recommendation for appointment to the board of governors. The Board of Governors does have the final say in terms of whether they grant privileges to the applicant. And with that being said, I'd like to turn it over to Ben, who will pick up on the credentialing pointers portion. You're on mute.
Ben, you're on mute. Yeah, you got to unmute. And you got to put the slideshow up too.
Oh, really?
Yeah.
Hold on.
It's on your other screen, probably.
On my other screen. So let me do
Yeah.
Share. Now can you see?
Yeah, I can see. We can see. Yes.
Okay, perfect. So all right, so back to what I was talking about, which is the medical staff. The medical staff is not only categorized by those 5 different categories that Como talked about, but they're also categorized by department. So like you'll have like surgery, and you'll have the radiology, and you'll have like pulmonary. So all of those different departments will have their own medical staff issues. So it's sorted out in a couple of different ways. The other thing that I wanted to point out is that the medical the MEC, the Medical Executive Committee, has the ability to actually appoint a bunch of different subcommittees, including committees on, let's say, people designing the bylaws, or obviously the peer review committee, or the health and wellness committee. These committees can be very instrumental in helping guide the flock of medical staff practitioners. So back to credentialing on this. When you're looking at credentialing, the bylaws should articulate in it what sort of a criteria the individual will be assessed on. So like, for example, their level of training, their level of certifications, whether they have to be actually board certified or only board qualified, their experience, the number of years in the field, and other things will also play into it, like character and the personal references that they get and the judgment. Now, one thing to keep in mind is every medical staff practitioner that's on staff needs to be reviewed at a minimum every 2 years, if not more frequently than that. Meaning that they have to be cross-checked for any sort of like reporting of violations, anything that shows up on their NPDB databases. It's really important to do that because that's what CMS requires. When it comes to actually disaster privileging, there should be disaster privileging provisions inside the bylaws. If they're not there, you may want to get them in. Ed is actually our Yoda on our team, and he is highly knowledgeable about these things. Anyway, we're here to help you if you need help with it. The other thing is, when a medical practitioner has been passed on from the chair over to the Medical Staff Executive Committee for review, if that person is declined, it becomes a reportable issue. So it's going to get reported to the NPDB for an adverse ruling on that individual. So you have to really be careful as to who is going before the MEC, because people's careers are on the line. Whether you're on the practitioner side or you're on the administrative side, you've got to really be careful of who you push forward for approval. Otherwise, majority of the time, what will happen is people will actually designate the file to be incomplete for lack of, let's say, experience or lack of training or something to that effect. And they should probably heed warning to that and just be on their way, and the file is deemed incomplete. And if it is deemed complete and it goes before the committee for approval and it gets declined, then a problem comes up.
Yeah, and let me add on that obviously you need to have a little due process on a declination to allow the individual who's being declined to address issues on the reason why they're giving on the declination. So. But it's also real important, obviously, for the person who's applying when they're filling out that credentialing application, that membership, the application itself, to be absolutely thorough. And if there's something in one's background that's a negative mark, be sure to address it fully, because that obviously can very well come up during the credentialing process, and just to make sure the background on it, let's say if one was disciplined at another hospital, that background is actually in the application, so that it's addressed and it doesn't surprise everyone and create a problem.
So here's the actual due process requirement according to the United States Code, Chapter 117, Section 42. And also, some of this stuff is actually elaborated in Florida Statute 395, as well as 456, and then the HCQIA, right? The HCQIA, which grants immunity to the committee, only grants committee for like peer reviews, and these sort of judgment calls, if it's done in furtherance of healthcare quality, because they wanted to actually provide a level of protection to the committees that are responsible for patient care and making sure that the quality of patient care is appropriate. So this immunity only applies if these four things are done. And these four, so the first thing being, whatever action is taken, it's got to be in furtherance of healthcare quality. Second thing that has to be done is that a reasonable amount of effort has to be put forth to collect all of the facts, not just the favorable facts towards a particular decision, but the holistic facts. The third thing is, if an adverse action is going to happen against that actual practitioner, that they be afforded a notice of hearing, a fair chance to be heard and hear their side of the story. And then eventually, the fourth prong on it is that the action that the committee takes against that practitioner has to be in proportion with the thing that wasn't done right. So you cannot over discipline them either, or you cannot under discipline them. You have to do it in proportion to the violation.
Yeah, I want to mention one thing. Obviously, these four, document these. This is the importance of documenting, because again, the Healthcare Quality Improvement Act provides immunity, and the reason why it provides immunity is so that those participating in it and reviewing it can freely discuss without fear of being, litigated against about the physician. But again, that discussion is on healthcare quality. It's on the facts. It's, again, giving persons notice of fair hearing rights, and that everything you're doing is warranted under the circumstances. And it's not being used as a ruse to, let's say, knock out a competitor or something like that. That's that's not permissible. So again, it's such important to document each of these elements as one's going through the review process, because if you don't document it and there's a negative consequence to the applicant then then might seek counsel and try to attack the immunity. So again, by documenting these things, you can keep your immunity there.
And keep in mind that the fairness is important, because if the applicant is denied credentialing, it's because it's going to turn into likely a reportable event back to the NPDB database. Next part is we're going to touch on peer reviews. What are peer reviews? Well, it's really a physician getting evaluated by other physicians, right? So it's really a physician on physician review of, let's say, the past year's trends of statistics that have occurred, or a particular activity that's been reported. And when that happens, and then they call concerns or fallouts. If a concern or a fallout arises, there's actually a step ladder of things that can be done before any of this becomes a reportable issue. And on this particular slide, we've pointed out the 7 basic sort of things that can be done without having to write up people, without having to get serious about the actual repercussions of it. You can go into actually collegial intervention. Yeah, so it's just basically, one friend talking to another colleague, right? You can educate the person, you can mentor the person, you can counsel the person, you can require that they get a second opinion before they perform a procedure. You can actually have them pick up a proctor for every time they maybe are doing a procedure. So when they're doing a procedure, they would actually have somebody watching what they're doing. All of this can also be balanced out with putting into place, courses that maybe relate to behavior boundaries, like such as anger management or sexual harassment. So these are a lot of potential things that can be done, nudges from different directions that can happen if a practitioner goes off, that the medical staff committee can do to rein them back in.
And there's a couple points in all this. Is the physicians that are participating in this review should feel comfortable to talk openly to the physician who's probably having an issue. and not feel embarrassed, but feel, because again, this is all covered by peer review privilege that's not discoverable so long as, you know, the purposes we just maintained earlier are there. They should feel very comfortable talking with them. They should document that they talk with them. And then when you get to this point of 7, if you're really at the point where you have to send what I always call the physician to quote charm school, you send them there, and it's by mutual agreement. The physician decides to go there, but then it's also important to get that physician to agree that the information from that course, it gets communicated back to the medical staff committee that's reviewing the physician, the MEC, so they can know how well the person did, he participated in it, and that he effectively graduated from that, and any further recommendations that behavior course might have with regard to any further restrictions they suggest he has, or further review over some period of time. And again, these are good. There are so many instances that I've heard of where a physician, if that physician's having a problem, let's say anger management or, you know, inappropriate behavior, and they really embrace the course, they could turn their career around. It's real important to let the physicians understand that they should be embracing this coursework to turn their career around and end up in a great path forward, so there's not future problems. Yes.
Good point. Thanks, Ed. That was good commentary. So what happens if the practitioner does not embrace those requests? Then what happens is that the MEC or the CEO can actually escalate the matter, and they can ask for an investigation to begin. And in the investigation, you have to have several things happen. There has to be an event or an occurrence that takes place that causes the investigation to be initiated, and then it could come in a form of actually even a routine review. Meaning, for example, if you're doing a year-end review of the statistics and you find the statistics to be out of whack on one particular individual, but in line with the others, you may want to just review that person's statistics and figure out why that was the reason. So that's the beginning of an investigation. Now, mind you, keep in mind in here, like we've pointed out, is you got to keep the fairness in mind. Fairness has to be an integral part of this investigation and disciplinary action and process. So during the investigation process, what can also happen is that the investigating committee can actually have an investigative interview with the practitioner and call them in for a fact-finding meeting to figure out what their side of the story was. And you know, that's really a better way to practice, although it happens without it sometimes. It's probably a better way to do it so you can understand that practitioner's side of the story. The other thing is the people that are put on the investigating committee can be either a set committee that's already been set, meaning like in advance, or it can be ad hoc individuals chosen by the MEC. So depending on the set of circumstances, you may have 90% of your things be done by the same 5 people that always review the same sort of complaints over and over, or you may have like a specialized knowledge-based committee that you might need because you might have a very specialized skill set need to be able to evaluate that individual. Now, keep in mind, in the investigation committee, competitors can play a role in it. So if the practitioner has a competitor and the competitor is investigating them as a part of that investigative committee, that's allowed. However, you just have to make sure that you're able to keep it free of like a fundamental conflict, like a conflict where they have their economic interests at heart to see the other practitioner out. So competitors are allowed in the investigative state, but again, it's not recommended, but it's allowed. But competitors are not allowed at the hearing panel stage, where there is an ultimate decision being made over the practitioner. So it only makes sense that you just wouldn't allow a competitor to obviously make a decision against a practitioner because they're at odds with their interests. Now, sometimes what you'll see is a peer review committee or a medical executive committee may not want to get involved. And the reason why they may not want to get involved is because they don't want to get pulled into a whole bunch of lawsuits or something and have allegations of defamation and slander and things like that be put up against them. Now, mind you, most hospitals do carry D&O coverage. That D&O coverage allows for the medical staff committees to pick up defense counsel, and that's defense counsel paid for by the insurance company. So, that is a consolation, because it helps protect the people that are reviewing the physicians. Keep in mind that for certain specialties, you might need to go outside of your normal network of people to go and pull the right person with the right knowledge base to be able to evaluate one of your practitioners. So it's really important to make sure you get the right person from the right industry with the right sort of a background to help you evaluate what actually happened. Because something that may look awry to you and me may not be that far off the wall if you're practicing in that industry. Like, for example, interventional radiology, right? Or some sort of a specialty surgery. Some of those things that happen that may sound odd to you and me may be very normal and recurring in that industry. Ed, anything else you want to add there?
No, I think it's right. I mean, again, keep in mind, that often happens. Let's say if you have, let's say, a very unique physician, such as interventional radiologist, you only have one on your medical staff, and then that person needs to be reviewed for whatever reason. That's when you often will see them bring someone else in from the outside to do that actual review. But that's important. Again, if the committee itself, it's a peer review is privileged, but again, there's always that risk that's going to be attacked, especially by a physician who loses their privileges. So that's why you want to have that D&O insurance in place, so they feel more freely and not going to be costing them their legal fees.
Makes sense. Now, the investigation process, the way it runs is like this, like on step number 1, the investigating committee is now actually goes out, collects all the facts, and does the analysis of the facts, but doesn't necessarily make the recommendations unless they're specifically asked to make a recommendation. So people in general should not be expecting a recommendation from the investigating committee, because they're generally silent. But if the MEC is asking for a recommendation, they may be prompted to make that recommendation. Then what will happen is once the facts are captured and the analysis is done, it flows up to the medical staff executive committee, and at the medical staff executive committee, they have to decide either to take no action because it wasn't nothing is warranted, or do a letter of reprimand, or number 3, they can either suspend, reduce, or revoke or restrict their privileges. And if the privileges are being restricted or reduced, that turns into essentially a reportable event. Keep that in mind. So the first 2, no action is okay, letter of reprimand is okay, but when it comes to actually the 3rd item, where people's privileges are being affected, they now have to be put forth before the Board of Governors. The Board of Governors will then ratify the MEC. Sorry about the spelling mistakes on that. Ratifies the MEC's action. Yeah. Yeah. I know, I'm seeing spelling errors all over this thing. Sorry about that. But because there is adverse action then taken against the individual, you're going to have to keep in mind that becomes a reportable event.
Yeah, one thing's real important to keep in mind too is once this investigation begins, that if the physician leaves the medical staff, that is reportable in and of itself, regardless of whether or not the physician had a problem, really was doing something. So sometimes it's important before the investigation begins, because some event occurred, to get dealing with the attorneys, to get the attorneys for the hospital, the attorneys for the physician, maybe the physician's attorney for the physician's employer, together pretty quickly, and see, hey, can we work something out? And perhaps before that investigation begins, they might want to work out that the physician, leaves employment and goes away. Now, the negative part of that is if the physician really is, providing a problem with the quality of healthcare. You're effectively, by doing that, you might release a poor physician into the community. And so you have to kind of balance that out too. But again, if if it looks like the physician's going to be fired from his employer because of what's happening, and that's real important to make sure that you're working things out, especially if the physician is in a group that has a exclusive with a hospital, because sometimes it says that if you're no longer employed, those exclusive coverage agreements, if you're no longer employed by the group, then you have to resign your medical staff privileges. So, all these little things come into play. So if you get fired while an investigation occurs, you have to leave your privileges, then all of a sudden that becomes reportable. So there's a lot of moving parts at the very beginning. So again, from the physician accusee side, it's so important that something's happening is to actually get an attorney to work through it. And again, it's also important to be coordinating with counsel when it's something serious, not the A and B, that's a letter reprimand or no action. Those are just things that go in the person's file, but it's not going to effectively affect their privileges. But when you start putting things in that affects a restriction, that is something that becomes important, because later on, should they apply elsewhere, they have to report that they were suspended or restricted to their new employer, things like that.
Good point. And it's really important that once that investigation starts, do not quit in the middle of it. Just don't let the person quit in the middle of it. It's got to.
It becomes a nightmare. I've had a physician deal with that. He just didn't pay attention and he quit, and all of a sudden it's like reportable, and he has to kind of figure out how to deal with it because now he has this mark on his record. So,
now, there's actually several rights of suspensions that the administrative side of the hospital has. One is if the medical staff committee sees that there is imminent danger to the health of an individual or a patient, then they're able to actually suspend the individual immediately. And HCQIA actually allows for a suspension for 14 days, so an investigation can be carried out, and that can be done without notice and without a hearing. That 14-day suspension is really just intended to be a quick look at what's going on with the underlying event. And if there's cause, then what they do is they proceed forward with the whole investigation. But to get a very precursory sort of a look, it'll take at least 2 weeks, maybe even longer, to investigate the actual full scope of an investigation. It takes even longer than that. Now, keep in mind, if the person stays suspended more than 30 days, then it becomes, again, a reportable event to the National Practitioner Data Bank. So sometimes what practitioners will do is they will immediately proceed to court, seek an injunction, so they can actually minimize the impact of their income, as well as minimize the blemish on their license. So some practitioners will actually proceed immediately to court because they want to stop all of this stuff from occurring, and they'll seek an injunction against the hospital. Now, that can obviously happen. So anyway, as the investigation goes on, then what happens next is back to the progressive disciplinary actions. Remember, there's 10 of them available to us here. We talked about some of these: the collegial intervention, the education, the mentoring, counseling, and requiring a second opinion from another physician before somebody performs a procedure. And it goes on to proctoring, attending courses, but then you have the precautionary suspension that you can do for 14 days. If it goes, now see this red box here, it says anything beyond the 30-day mark really becomes a reportable event. So after this, like this 14-day suspension, anything heavier than that, you've got to start looking at it with a different set of lenses, because you're impacting people's careers and how they're going to be affected on down the road, and how they're going to come back at the hospital if you're going to disrupt their career.
One thing I want to mention quickly, though, is this 14-day precautionary suspension that can happen at any time. They can happen like immediately, before you're having a proctoring, before you're having anything else, if it's serious enough. Let's say, for example, the physician all of a sudden turns out didn't pay his professional liability insurance and is no longer covered, right? by liability insurance was a requirement of the medical staff bylaws. You know, the hospital president could say, summary suspension right now, get that thing in place, get your insurance back in place. Or if there's something so serious that you can have a suspension in place immediately. So.
Or even like alcoholism, like finally, like when you see people on substance abuse, things like that, you can actually suspend the individual because you're affecting people's health. There's imminent danger involved in that, especially if somebody has the ability to like prescribe medicine or cut into people like the surgeon would. So what that means is that now you've got to step into the whole disciplinary hearing phase. And because privileges are going to be impacted. And these are essentially the 5 basic steps. Go ahead, Ed.
Yeah. I mean, so again, what hospitals will sometimes try to do to avoid these steps is if they have a closed staff and they contract with a group to be the one group for this closed staff and have a coverage agreement. Is in that coverage agreement itself to have something that says the hospital president can ask to remove a physician for certain reasons, and which then they remove them from providing services in that department, and again, effectively circumventing the due process rights. So from the physician standpoint, if your group is entering into one of these arrangements, you want to at least have some sort of due process built into those removal requests. And again, from the hospital standpoint, you want to be removing, if you're going to exercise that, remove for a proper purpose, not for an improper purpose.
Good point. So now the formal disciplinary hearing process, this is how it begins. There's first a notice of reasons that's issued. The notice of reasons is essentially a charging document, and in it, it'll state what was it that occurred that's causing their behavior to come under review. And it has to be stated with sufficient specificity so the practitioner knows what is being referred to. Obviously, names of patients and things like that are redacted, but you can refer to them by another key number or some other way of referring to it, another methodology that some of the hospitals use to actually refer to the same patient over and over at different stages, right? And to keep everybody kind of silent, to keep everybody out of the papers, they'll use a different numbering system for that to identify that person. So in that notice of reasons, the practitioner has to be given the ability to request a hearing. So once they actually request a hearing, the notice of hearing has to be triggered. When the notice of hearing comes out, you got to give the practitioner at least 30 days to get ready for the hearing. Because remember, the investigating committee has already done all of their work, right? So it's the actual practitioner that now has to step into and figure out what everybody else has seen. So with that, what's triggered is the pre-hearing discovery requirement. And in that discovery requirement, there will be an exchange of documents and an exchange of witnesses as to who's going to be saying, who's going to be speaking on behalf of either side. It's really important to go through these basic steps of, due process, because the practitioner has to be able to see what the underlying factual data points are that's causing them to be charged with the violation. In the hearing process, what hospitals will do is they will often go out and get a hearing officer. The hearing officer is literally a presiding officer that's there for ministerial purposes. Ministerial purposes meaning like they're going to help with the exchange of documents should something not look right or be right, or somebody has a complaint that there's a lack of transparency. They will also work with a hearing panel to make sure that the hospital as well as a practitioner get to make their case for their day to be kind of heard in court, although it's not a formal court, but before the hearing panel. Now, when it comes to the hearing panel has to be an unbiased hearing panel. You cannot have competitors on them. You cannot have people that are employed by the hospital system. You have to literally pick out fair people that are going to be on the hearing panel. And what the hearing panel does is they're looking at two things. One is they're looking at the evidence and the sufficiency of that evidence to warrant the recommendation that the MEC has come up with. So what they're basically playing a balancing act. Is the evidence sufficient to warrant the action that's being taken? And if they come up with a no, then obviously it gets declined. If they come up with a yes, then obviously then the person has their privileges modified. Now, a lot of times that's where it'll stop, but there's times that it doesn't. So either side then can actually proceed to court and seek a injunctive relief for the issues at hand. So the next step after this disciplinary hearing process is the court system. Now, a lot of bylaws, before you actually proceed to court, there is a step in the middle. A lot of bylaws will have appellate rights listed in them, and there's a due process procedure laid out in that. If it says that you have to follow that procedure, then you've got to exhaust everything allowed in the bylaws first before you can proceed to court. And that's how a formal disciplinary hearing process works. That's it. That was our seminar. Any questions?
Hi, this is Frank here. I thought that was an excellent presentation. We had mediation go before heading to court, and it was quite successful in a number of cases. Fortunately, the 5 years that I was a CMO in Naples, the system is very successful, and it's important to have a healthcare attorney firm make sure that they go step by step. If you're the hospital, let's say if you're the provider hospital, make sure that you are that all of your documents are read by that healthcare attorney firm before they're submitted, and making sure that you follow their protocol and their advice. And that's
a good
important.
point, Frank. That's a good point, because what will happen is if you actually bring in outside counsel versus even inside counsel, the outside counsel will help you test your evidence and will help you test your due process clauses in your bylaws to make sure that it's going to be able to pass muster. And I think so. Getting an outsider's opinion is highly important, and keeping them involved is important.
Well, the system had a firm on retainer. So basically, they were working with us on a regular basis. Yeah. And we were using, I can tell you, it was Horty Springer from Pittsburgh. And they were we were using their bylaw models and applying them into our system quite successfully.
Yeah, that's a good point. Yeah, it's very, very good point. Yeah.
No, that's a good point. Getting that sort of consulting is like priceless on both sides, depending.
Yeah. Hey, Ben, again, I got a question. Yeah. How does this, and we've got a few minutes left, how does this also relate to large medical practices? There are some giant places out there like Gastro Health and a lot of those places. Is it a very similar type situation, although it's not a hospital? Does it go for kind of a large medical group too?
Yeah, that's usually more of a employment situation, and I think Ed was alluding to.
Yeah,
the fact
I was with a large group. Let me address that. Keep in mind that yes, it's important to have a structure in place for your employed physicians. It's important to have the due process rights, to have a credentialing and all that. But the rules for the requirements are not. They're not part in the Medicare conditions of participation area. So the formality of it is just not there, but it's important to have a formal structure in there and to give the physician due process rights. You also may, depending upon the size and structure, not have a reporting obligation to the National Practitioner Database if it's a physician organization. So it's you just got to look at on a case-by-case basis and how they're structured. But yes, they need to have a structure. Obviously, it's oftentimes less formal because it's all physicians within the organization and within the governance structure. but yes, you need to have something. You do need to have it in there. And I would say oftentimes groups sort of don't have it. I mean, so they should put something in place.
Good question.
A question regarding when a practitioner would involve their own counsel during an investigative procedure.
Yeah, I would say if they're under investigation, they should be calling an attorney. If it's something that may rise to more than just a disciplinary letter, but if it's something where their privileges are at stake, and they should have counsel involved on their side. I would agree with that.
Yeah.
During hearings, when during the process would their counsel appear?
Okay, so with regard to the hearing itself, sometimes it does not, depending upon how the bylaws are written, they may not permit a physician at the hearing. Attorney at the hearing itself. It depends on how it's drafted, but they do need to have an attorney with them and counseling them on how to set forth and go forward.
Great, thanks.
Now, it may. I've actually been able to help physicians before something hit the fan, right? So, I think that physicians should always keep an eye out towards, hey, what's coming down the pike? Something went wrong. It didn't go exactly right. Maybe it's time to start talking to an outsider legal counsel to figure out what's coming up down the pike. They may have already gotten a nudge. They may have already gotten some of the counseling. But as soon as that sort of stuff starts to happen and it doesn't look like there's any letting up, I'd start talking to an attorney at that stage as a physician. Because I think that's a time to kind of start figuring out, hey, do we have a real issue that we want to bow out? Or are we going to wait for the investigation? Because if the investigation is going to happen, you don't want to quit in the middle of the investigation, obviously. So,
great.
Yeah, good question. Thanks, Joe.
Good question, Joe.
All right, cool.
Any other questions? What we have? Okay, Ben, we're up to 12:29, so we made the hour. Once again, you and your crew have been able to put this all into 1 hour. We appreciate everybody coming to the seminar, the webinar this afternoon. And you'll see in the chat box, if you have the chat box, there is a link to the next event, which is Navigating Hospital Contracting Issues. And that's going to be on December 15th, again, from noon to 1. So hopefully everybody will sign up for that. And we will see you, if no other questions, we will see you in 2 weeks. Ben, any parting words, Ben?
No, that's it. That's it. I mean, I like that last question what Joe mentioned, because I think that often the value of getting a consult done ahead of time is overlooked, especially by physicians that are about to get pushed out of a hospital system, and I've seen physicians get pushed out over silly reasons, really bad reasons. And I've seen them not get pushed out, even though there was really great reasons. So, it's not like the system is entirely predictable. So you got to get as many eyes and ears on your issue or occurrence, just so you get a more holistic sort of a look at it, and even getting other physicians involved. So, to the extent that we're here, the three of us are here to help any physician that has those questions, or any general counsel, legal counsel. As they're going through it, and we're happy to investigate and do and help with the whole process as an outside counsel. So that's it.
Appreciate it. So if it's not you who needs Ben's help, if you know somebody who does, or somebody getting into a situation, make sure they give Ben a call or email him, and his information is on the slide right there.
Fantastic.
Great. Thank you much. Guys. And we'll have this up on the South Florida Hospital News website within a day or so. And Ben will have it up on his website too. So thank you again for coming, and we'll see you in a couple of weeks.
Thank you, guys.
Thanks, everyone.